Welcome SIE candidates, employee conduct and reportable events. This video segment will review the process by which individuals register with FINRA as associated persons, as well as the requirements for updating FINRA about any relevant changes in an individual's application. This segment will expand on the registration documents introduced in the previous segment. Additionally, it includes an analysis of how member firms are required to handle customer complaints and the various issues that lead to reporting obligations for individuals and firms. Employee conduct, registration of representatives and Form U-4. Any person who engages in the securities business of a member firm must be registered, except for employees whose activities are solely clerical or ministerial. Member firms must investigate the good character, business reputation, qualifications, and experience of personnel they plan to register with FINRA. To start the registration process, a person must complete Form U-4, the Uniform Application for Securities Industry Registration or Transfer, Form U-4. On Form U-4, an applicant must answer questions about personal data, including residential and business history. The form also asks a series of questions about the applicant's history regarding violations of laws or SRO rules. For example, applicants are asked whether the SEC has ever issued an order against them related to investment activities. Disclosures by applicant. Page 3 of Form U-4 contains questions about the applicant's involvement in criminal legal proceedings, felonies and securities-related misdemeanors, regulatory disciplinary actions, civil judicial actions, customer complaints, terminations, financial events, bankruptcies, liens, bonding denials. Applicants who submit false, incomplete, or misleading information risk having their registration suspended or revoked. By signing the U-4, registered representatives agree to file timely amendments within 30 days if any details on the form change. Failing to fully disclose relevant facts and circumstances could potentially lead to a person being barred from the securities industry. A yes answer to any questions about violations of laws or SRO rules generally requires an explanation on the appropriate disclosure reporting page, DRP, of the U-4, and could result in a statutory disqualification. Arbitration disclosures. Form U-4 includes a pre-dispute arbitration clause. By signing this form, a person agrees to use arbitration to resolve disputes involving their employer, other member firms and associated persons, and customers. The member firm must make the following disclosures regarding arbitration. You agree to arbitrate any dispute, claim, or controversy that may arise between you and your firm, a customer, or any other person required to be arbitrated. This means you give up the right to sue a member, customer, or another associated person in court, including the right to a jury trial, except as provided by the rules of the arbitration forum where a claim is filed. A claim of employment discrimination including sexual harassment in violation of a statute is not required to be arbitrated under FINRA rules. Such a claim can be arbitrated at FINRA only if the parties agree to arbitrate it, either before or after the dispute arises. The rules of other arbitration forums may differ. A dispute under a whistleblower statute that prohibits pre-dispute arbitration agreements is not required to be arbitrated under FINRA rules. Such disputes may only be arbitrated if the parties agree to arbitrate after the dispute arises. Arbitration awards are generally final and binding. Courts have very limited ability to reverse or modify an arbitration award. The scope for obtaining documents, witness statements, and other discovery is generally more limited in arbitration than in court proceedings. Arbitrators are not required to explain their reasons for an award unless, in an eligible case, all parties jointly request an explained decision at least 20 days before the first scheduled hearing. The arbitrator panel may include industry-affiliated arbitrators or public arbitrators, as provided by the arbitration forum's rules. Some arbitration forums may impose time limits for filing claims. In some cases, ineligible claims may be litigated in court. Waivers. A disqualified person may apply for a waiver from an SRO to join or rejoin the securities industry. However, approval requires an eligibility proceeding. If granted, the SRO must notify the SEC, which ultimately can overturn the waiver. If the SEC has no objections, the person is often placed under enhanced supervision procedures at their employer, as detailed in the firm's Written Supervisory Procedures, WSP. Generally, a disqualified prospective employee may not associate with a FINRA member in any capacity until the waiver is granted. If currently employed, they may be allowed to continue working in a limited role pending the outcome of the eligibility proceeding. Review of new hires. Each member must establish and follow written procedures to verify the accuracy and completeness of information in a new or transfer Form U-4. This review must occur within 30 days of filing. If previously registered with FINRA, a broker-dealer must obtain and review the latest Form U-5. The termination notice for securities industry registration. Review of Form U-5 must be completed within 60 days of the application for registration. If requested, the applicant must provide their Form U-5 within 2 business days. The Central Registration Depository. The CRD is an automated database containing employment and disciplinary histories of registered persons. It handles application processing for agent registrations and withdrawals for agents and broker-dealers. If any information on a Form U-4 changes, an amendment must be filed promptly. Updating Form U-4. Disclosure or updates are required if a person has been convicted, charged, or pled guilty, or no contest to any felony or misdemeanor involving investments, investment-related business, fraud, false statements or omissions, wrongful property taking, bribery, perjury, forgery, counterfeiting, extortion, or conspiracy. An arrest without charges does not require reporting on Form U-4 or to FINRA, but firms often have in-house rules requiring notification if a registered person is arrested. Form U-5. After a registered person resigns or is terminated from a member firm, the firm must notify FINRA within 30 days by submitting Form U-5, including the relevant details. The firm must also provide the former employee with a copy of the form. Form U-5 states the reason for the registered representative's departure, voluntary or involuntary, and must be updated within 30 days if any answers to certain questions change after termination. If a broker-dealer receives a written customer complaint after the registered representative has left the firm, it is still required to notify FINRA, regardless of how much time has passed since the registered representative's departure. There's no obligation to send a copy of the complaint to the registered representative. Even after termination, FINRA retains jurisdiction over any associated persons previously employed by the broker-dealer for 2 years. Therefore, someone who terminates her registration but wishes to return as a registered representative without requalifying by examination must do so within this 2-year period. Form U-6 is used by regulators, states, and jurisdictions to report disciplinary actions against registered representatives and firms. FINRA uses Form U-6 to report final arbitration awards against registered representatives and firms. As with Form U-4 and U-5, any information entered on Form U-6 is processed into the CRD system, and some of this content may be accessible to the public via FINRA's BrokerCheck website. Regarding the release of disciplinary information, BrokerCheck is FINRA's public disclosure program that provides details about the disciplinary history of member firms and registered representatives. It offers information on individuals who are currently registered or have been registered within the past 10 years. This data is stored in the CRD system and can be accessed by the public through a toll-free phone number or the FINRA regulation website. The details include the current employer, 10 years of employment history, and all approved registrations, certain legal and regulatory charges and actions against the registered representative, such as felonies, specific misdemeanors, civil proceedings, and investment-related violations. Pending customer-initiated arbitrations and civil proceedings involving investment activities, arbitrations or civil proceedings that resulted in awards to customers, and settlements of $10,000 or more in arbitration, civil proceedings, or complaints involving investment activities. Written customer complaints alleging sales practice violations and damages of $5,000 or more filed within the last 24 months. Formal investigations involving criminal or regulatory issues. Employment terminations following allegations of violations of investment statutes or rules, fraud, theft, or failure to supervise investment-related activities. If a registered individual disagrees with the information on BrokerCheck, they must file an amended Form U-4 with FINRA. If a person is no longer registered but was registered within the last 10 years, they must submit a broker comment request form to FINRA to update or clarify the information available on BrokerCheck. In terms of investor education, FINRA's Investor Education and Protection Rule mandates that member firms provide each customer, at least once a year, in writing, including electronically, with the FINRA BrokerCheck hotline number, the FINRA website address, a statement about the availability of an investor brochure containing information about FINRA's BrokerCheck. However, firms that do not hold customer accounts or funds or securities are exempt from these requirements. MSRB rules also include an investor education rule, requiring disclosures at least once per year regarding the entity's registration with the MSRB and SEC, the MSRB website address, the availability of an investor brochure on the MSRB's website which explains the protections under MSRB rules and details the process for filing a complaint with the appropriate regulatory authority. Previously, MSRB rules specified that investors would receive complaint information only when filing a complaint with or about a firm. Now, firms are required to annually inform customers about the educational materials available. Regarding expungement, if information in the CRD system is inaccurate, FINRA has established procedures for the removal, expungement, of contested information related to arbitration cases from a registered representative's CRD record. This removal of information from the CRD is only allowed if the claim, allegation, or information is factually impossible or clearly incorrect. The registered person was not involved in the alleged investment-related sales practice violation, forgery, theft, misappropriation, or conversion of funds. The claim, allegation, or information is false. Once information is taken out of the CRD system, it is permanently deleted and no longer accessible to the investing public, via broker check, regulators, or potential employers. FINRA defines a complaint as any written statement from a customer or anyone acting on their behalf, claiming a grievance involving any person under the control of a member firm in relation to soliciting, executing transactions, or handling securities or funds of that customer. If a complaint is received, the original must be forwarded to a supervising principal, who is responsible for reviewing and initialing it. Member firms are required to keep a separate file of all written complaints, including emails and texts, at each office under supervisory authority for 4 years. This file must include a description of any actions taken by the member concerning the complaint and should contain or refer to any related correspondence. Responses to customer complaints can be written or oral. Even if no complaints are received, a complaint file, even if empty, must be maintained. Member firms may need to file reports with FINRA about certain customer complaints and other incidents. If required, these reports must be filed promptly, no later than 30 calendar days after discovering the event. Reportable events include a firm or associated person is the subject of a written complaint alleging theft, misappropriation, or forgery, is found to have violated securities laws or regulations, or standards of conduct of any regulatory or professional organization, has been denied registration, expelled, enjoined, ordered to cease and desist, suspended, or otherwise disciplined by any securities, insurance, or commodities, regulator or organization, is named as a defendant in legal actions by regulatory bodies alleging securities, insurance, or commodities, regulation violations, has been indicted, convicted, or has pleaded guilty or no contest to a felony or misdemeanor involving securities, bribery, burglary, theft, robbery, extortion, forgery, counterfeiting, fraudulent concealment, embezzlement, fraudulent conversion, or misappropriation, holds a position such as director, controlling stockholder, partner, officer, or sole proprietor of, or is an associated person with, a broker-dealer, investment company, advisor, underwriter, or insurance company that was suspended, expelled, or had registration denied or revoked, is involved as a defendant or respondent in civil litigation or arbitration resulting in an award or settlement exceeding $15,000 for associated persons or $25,000 for member firms, is subject to any action by the firm against an associated person involving suspension, termination, withholding of commissions, or fines over $2,500. FINRA members must submit quarterly reports to FINRA detailing statistical and summary information about customer complaints, even if no prior report is triggered by complaints received. These reports are due on the 15th of the month following each calendar quarter, but if no complaints were received, no report is required. The terms of a customer's settlement with a broker-dealer may be confidential. Although the customer cannot disclose the terms, the registered person still needs to report these to CRD. The SEC emphasizes that reasonable supervision requires strict adherence to internal procedures, WSP, and principals must also identify problematic situations despite limited information. Supervising principals should watch for any signs of potential violations, known as red flags. Ignoring potential issues increases the risk of failure, so principals must respond. When a red flag is found, a supervisor must 1. Investigate the situation. This involves making a reasonable effort to gather all relevant facts and understand what led to the red flag, including reviewing available documents and possibly contacting the client directly. Regulators want to see ongoing communication between supervisors and clients of the registered representatives they oversee. 2. Document the investigation. This includes recording all reviewed documents, interviews, and client contacts in writing. This documentation is crucial if regulators conduct a formal review. 3. Follow through to a conclusion. Often investigations involve multiple supervisors or departments. The supervisor who initiated the investigation must ensure it is resolved, which might result in finding no violation. Customer complaints and other allegations often stem from poor communication between registered representatives and clients and/or between registered representatives and firms. A red flag doesn't necessarily indicate that a violation has occurred. Regardless of the findings, the supervisor must conclude the investigation and document the conclusion and how it was reached. Any investigation should be as objective as possible and should always include evidence beyond just an employee's word. This could involve consulting other supervisors or members of other departments such as compliance or legal. The employee's past conduct should always be considered. Violations are often not isolated incidents but part of a pattern of ongoing misconduct. A registered representative with a history of previous misconduct might be a red flag for further investigation. Additionally, hiring a registered representative who has demonstrated a pattern of unauthorized transactions without proper monitoring has been viewed as a failure to supervise by some regulatory authorities. To keep this straightforward and easy to understand, we'll be brief and concise. Join us for a follow-up video where we will continue the discussion. As always, please like this video so others can benefit. If you're new here, we invite you to join our community with a free subscription.